Welcome to the Top 12 Highlights. From Chapter 2, we're looking at the constitutional foundations. I'm Mr. Rodman. Thank you for joining me. Let's take a closer look at the Constitution. In class we talked about the articles in terms of the roles and responsibilities that were outlined in this. We looked at this in the first three articles, the Article 1 being the roles and responsibilities of the legislative branch, Article 2 with the executive branch, and Article 3 with the judicial branch. We then look in Article 4 at the state roles and the idea of federalism. This is where states come in terms of honoring their privileges and immunities. If you have a marriage license in one state, you don't have to get married in another state just because you've moved. You can do that in one state and it will be honored in another. The same thing with a driver's license. I don't need to get a Virginia driver's license just because I'm driving in Virginia. I have a Maryland driver's license and that does suffice. Article 5 is about amending the Constitution. We've done that 27 times. We'll talk a little bit about that later. And then Article 6 is the Supremacy Clause, the idea of if national and state governments conflict, who wins? Supremacy Clause says it's the national government. We'll see in a case, McCulloch v. Maryland, where that does play out. Maryland playing a role in that. And then Article 7 is the ratification of the Constitution. We didn't need unanimity. We only needed 9 of 13 states to ratify the Constitution, which obviously took place. Importantly, trying to get Virginia and New York in there because they were big states, but the idea being that the Constitution would be ratified without having everybody on board. And that would be important when it came to other things like the amendment process and so on. Their unanimity wasn't necessary. The Bill of Rights being the first 10 amendments, but obviously the Constitution will be ratified prior to the Bill of Rights being outlined there. Amending the Constitution, as I said, only 27 times have we done that, pretty significantly in terms of different roles, and we'll look in more detail at those amendments as part of the Constitution quiz that we've done some of those already. The first 10 amendments, being the Bill of Rights, and so really only 17 times since then. Now, the 27th Amendment actually was originally included in the 12 proposals that Madison gave to be amended and ratified as part of the amendment process for the Bill of Rights. That would come later. That would be congressional pay. You must sit in election for an election before the pay increases take place. But otherwise, we've seen everything from post-Civil War with the 13th, 14th, and 15th Amendments to presidential succession. The role of D.C. in having a vote, 25th and 23rd Amendments for 25th for succession, 23rd for D.C. votes, and a number of other suffrage amendments in terms of giving women the right to vote, 18-year-olds the right to vote, 18, 19, and 20-year-olds the right to vote, and as I said, amending and curbing congressional pay, no increases until they stand for another election. So a lot going on. Federalism, going back to this idea we just merely broached in Article 4 of the Constitution, the idea of federalism, the sharing of power between national and state governments. The idea was to limit the power of government by giving power back to the states so that the central government wasn't too powerful. The last thing that the founders and framers wanted was people not on board because it was too strong of a central government. So that was a major concern. We'll cover a lot more on federalism in Chapter 3. Montesquieu has a huge role here because separation of powers is essentially coming from him, the idea of separating the roles and responsibilities, the powers of government into the legislative, the executive, and judicial, Article 1, 2, and 3, in terms of the role that they play, and then having different roles entirely and responsibilities. The legislative branch making the laws and ratifying treaties, the Senate in that role, and then advising consent of any nominations to the cabinet and to diplomatic roles, ambassadors, and so on. So the legislative branch taking that on, and then the executive branch, the enforcer of the laws, really trying to carry out and administer enforcement of the laws that are being made through the various bureaucratic agencies and departments that are there, and then the judicial branch to interpret those laws and to really outline the roles that interpretation plays in declaring a constitutionality or in many cases when they're looking at legislation, it's because of the unconstitutionality. They don't look at every case. They don't look at every law. They're only looking at it if there is a constitutional question or something that goes against the Constitution in terms of the law that's being made, or some order or act or order that's being outlined. So we do have checks and balances in relation to this. Obviously, the legislative branch makes the laws, so the legislative branch can also approve nominations that the president makes. They approve the budget. They can override a veto that the president may make. And to the court, they approve nominations. So they're confirming the president's nominees to the court. That's the role the legislative branch can play. Now, the executive branch can check the legislative branch by essentially vetoing legislation. The judicial branch can essentially declare any laws that the Congress passes as unconstitutional, and those are really the checks that the branches have on the legislative branch. Now let's look at the executive branch. The executive branch has the power to nominate officials to cabinet positions and ambassadorial positions and so on, and to the court, to the Supreme Court, those nominees being ratified, being approved, advise and consent, if you will, to the Supreme Court. And the Senate would have that role. Now, the legislative branch nominates those judges. That's kind of the check that the executive branch has on the judicial branch. And then the judicial branch can actually declare presidential acts or presidential orders to be unconstitutional. We've seen some of these play out, some that have been ruled unconstitutional, some that have been ruled constitutional, with the president's immigration policy, with the president's the quote-unquote Muslim ban. All of these have played out in the courts in terms of interpretation, and that is their constitutional role as checking and balancing the executive branch. Now, the legislative branch can also check the executive branch, as we mentioned, by approving a budget that the president may offer, but also approving those nominations and impeaching the president or members of the cabinet for high crimes and misdemeanors, a role that the legislative branch plays. Now, keep in mind that the House impeaches, the Senate holds the trial for removal. So there are differences there, and we'll talk more about those later. And then the judicial branch, their roles and responsibilities in the checks and balances system really is about declaring laws unconstitutional or declaring presidential acts or presidential orders unconstitutional. And then the legislative branch can check the judicial branch by confirming the president's nominees or rejecting the president's nominees. And the executive branch then, in nominating judges to the high court and to federal courts, also serves as a check on the judicial branch to make sure it's in line. So all three branches checking and balancing each other so that there isn't one superpower branch that controls all of the government. And again, this is part of that pluralism by design. No one can control all of the branches, all of the levels of government all at the same time. So we see, and this plays out in Madison's design, we see a lot of divided government. Why? It wasn't just an accident that it is hard to pass laws and to get things accomplished. It takes a majority of Congress. It takes a president that's on board and really working together to pass those things, to make sure that the laws that are passed and the laws that are enforced are good ones, that they have been vetted, that they have undergone deliberation, that they are important enough to have been scrutinized, and witnesses have been brought in, expert witnesses in committees, holding hearings to ask them their opinions on how this type of a law could play out. All of these are important. So when we hear about, divided government versus unified government, we have seen unified government where we have gridlock. A good example, back before the 2018 election, we had a Republican Congress, a Republican president, and they didn't seem to be able to find room on immigration to have to pass a comprehensive immigration plan. They also had trouble passing a budget. And so it's not just divided government that creates gridlock. If you don't have people in your own party that are on board, there can be gridlock there as well. So this leads to the conversation of partisanship, the idea that we have a lot of partisanship and both sides are intensely partisan and becoming more partisan, party-oriented, if you will. Republicans only voting with Republicans and Democrats only voting with Democrats, which makes it really hard to find common ground in the middle, thus creating more gridlock. as we see here. And that can be problematic, especially when you're trying in difficult times to solve problems for the American people. And obviously back home, when you're trying to bring home the bacon and explain to them how important your role is and what you're doing is worthwhile, it's really hard when gridlock gets in the way and keeps you from doing that. So, but unfortunately or fortunately, no matter which side you take, it is by design. Madison and the founders designed it that way. They wanted the laws that were passed to be good ones and to be ones that had been thought out and carried out by a majoritarian type of politics within Congress and then enforced by the executive branch. So let's look at judicial review for a second. This is the idea of determining whether a law or a court decision or something, a lower court decision, or a presidential act or order is constitutional, okay? The courts, let me be clear, the courts do not look at every law that's passed. They don't look at every presidential act or order. They don't look at every lower court case that is handed down. They only look at it if it is a constitutional violation, that it goes against the Constitution. It potentially could be unconstitutional. Now, on the high court, on the Supreme Court, you need 4 justices to sign on to that. That's called the rule of 4, and we'll talk more about that later in chapter 14. But the idea here is that you have a constitutional question that is involved in terms of, is this constitutional? So if the law goes against the Constitution, the Supreme Court, 4 of the 9 would decide to hear the case, or it's not even a law, it could be a ruling by lower court, and they would determine whether or not it went against the Constitution. They would issue a ruling, and it very well as they dig into the details, they find that it is constitutional. That does happen. In some cases, they find that it's not constitutional. So they kind of go back and forth on that particular issue, but the role of the court, and as has been handed down since the days of the Marbury versus Madison case, which we'll talk about in a second, but this really is where judicial review came from, the idea of interpretation by the courts to determine and interpret the law to see if it goes against the Constitution. Now, the Marbury versus Madison case, in a nutshell, was basically about some appointments that the president, the outgoing president, John Adams, was making at the 11th hour before he was leaving office and Thomas Jefferson was coming in. He wanted these appointments to go out, so he had Madison prepare them. But the idea was Madison was coming in and saw these on his desk, saw these on the desk and decided to ask the new president whether these should be delivered. An appointment wasn't official until it was delivered, and the idea there was that once it was delivered, then the person could take the post, and until then they couldn't. And so Madison asked the new president, Mr. Jefferson, Mr. President, do you want me to carry these out? And he's like, no, I want to appoint my own people. Marbury, who was supposed to be undergoing this, and when this whole transition took place, he knew that he was getting an appointment from John Adams, but basically appealed to Madison because he had never gotten the appointment and said, what's going on? And of course, this ensued because Madison, of course, wasn't going to deliver the appointments. Jefferson wanted to appoint his own. So Marbury sued. This ended up in the court, and the Supreme Court, essentially with this case, helped to determine whether or not they would look at issues to be constitutional or unconstitutional. Now, the good news, bad news is that the court did side with Madison and with Jefferson in determining that the new president had the authority and obviously the power. If these appointments hadn't been delivered, then the new president certainly didn't have to carry them out. It wasn't something that writ of mandamus, the idea of having to carry something out, having to do something, was required by the court. Quite the contrary, they said Madison could, if Jefferson made his own appointments, Madison could carry those out. But the most important significance here, and why I say that Jefferson won the battle but lost the war, was because now this is going to be a role, the Supreme Court is going to be playing a role in the idea of judicial review, the idea of determining whether a law is unconstitutional, including a presidential act or order. Up to this point, they didn't really play that role, and Jefferson was like, well, now they're going to be all in my business, of course, and that would be the standard that we see today. Really, Marbury versus Madison was the case that really started us down that road. So we see today that and we saw this with the civil rights movement, when all other options have been exhausted, we turn to litigation, and we turn to the courts to really right the wrongs and the injustices that we see there. So they do have the Supreme Court does have the final say on that. It is kind of the buck stops here, equal justice under law, and then from there, from that Marbury versus Madison case is where a lot of this emanates. So let's kind of pivot here and look at the amendment process and some of the meanings of the Constitution. One of the things that the founders didn't do was go into a lot of detail in some areas of the Constitution, because they were expecting Congress to elaborate or fill in the blanks on some of that. And so Congress did do that, in fact. The Judiciary Act of 1789 was really the structure for the courts beneath the Supreme Court, because Congress does have the power to do that. They can modify the number of people on the Supreme Court, but they can't modify the Supreme Court in terms of taking it away, or they can change their pay. They can increase their pay but not diminish it. Article 3 states that. But the Judiciary Act is basically organizing all of the federal circuit courts and the federal courts across the country that are national in nature, and that is the backbone of the system that we still have today in the federal and federal and circuit courts that we have. So the Congress really does have some leeway here in terms of determining the meaning of the Constitution, and the Supreme Court looks at that in terms of trying to deliver on what is in the Constitution, whether it's constitutional or not. So there's a lot of gray area in terms of that elaboration. Impeachment is one of those, and it's a great example because as you can imagine, we're hearing a lot of that these days. And the Constitution basically is pretty vague on this topic. It's just basically listing that the president or vice president or cabinet members can be impeached. And by the way, Supreme Court justices as well. We haven't had a Supreme Court justice impeached. We have had circuit court judges, federal judges, that have been impeached for bribery and other scandals, but we have, impeached and removed from office. So let's be clear there. Samuel Chase was impeached, but he survived the trial in the Senate on the Supreme Court, so he survived that. But the idea here is that high crimes and misdemeanors, what does that mean? How does it relate into today's context? It's pretty broad, and so that's really the differences in terms of what plays out there. Presidential acts and executive orders, this has the full force of law. It's like Congress passing a law, and this President Obama actually did this quite a bit. President Trump has done some of this as well, and basically President Obama probably said it pretty well. I have a pen, and I can sign an executive order, and if Congress won't do the job, then I'll carry out my constitutional responsibilities. And President Trump has basically followed that in doing similar things, very different ideologies in terms of what they're carrying out, but using that presidential acts and orders to use executive orders in that capacity when they can't agree with Congress and there's too much gridlock. So we've seen that play out back and forth. We've also seen the Supreme Court step in on constitutionality issues related to that, but that is something that we've seen in the last two administrations. We've also seen executive privilege, where they're saying, hey, people closest to us, they don't have to testify before Congress. Those conversations are confidential. They're issues of national security, and we need to make sure that we protect them. Impoundment of funds is something coming out of the post-Watergate era, but really the idea that Congress has the power to disperse money, and this is where President Trump, in trying to build the wall on the U.S.-Mexico border, has found difficulty because with Congress having the power to disperse funds, they're pretty specific in terms of how those funds can be laid out. There is some discretion in terms of the agencies and how they implement the law and use funds to do so, but otherwise there's not a lot of wiggle room in terms of just one big pot of money that's sitting there, which is why President Trump has had some challenges in terms of how to build the wall, how to carry that out. And so that continues to be a point of contention between Congress and the president on that point. The power to send troops, and there's no declaration of war, but president is commander-in-chief. Under an executive order or presidential act, the president could send troops into battle. And the president, obviously, Twitterer-in-chief, uses this bully pulpit. Never have we seen the bully pulpit used in quite the same way as we have by taking to Twitter, as President Trump has done, in using Twitter as kind of the bully pulpit sounding board, and really kind of bypassing the media in a lot of ways to go directly to the audience that have followed him in order to get the message out. And obviously the media pick up on those reports and report it, but the idea is that bully pulpit is very strong. Somebody in Congress gets up and talks about, the wall or whatever, and maybe the local paper listens, but president gets up and talks about it. You've got the national media attention for sure. The perception is very different there for the president as for 535 members of Congress. So judicial review, judicial interpretation, we see a lot of court cases playing out, and we're going to come back to these, especially in Chapter 14 when we look at the judicial branch and some of the landmark cases, especially as we go into the Unit 3 and the civil rights and civil liberties. But we continue to see judicial interpretation. We saw it with Brown versus Board. In Plessy versus Ferguson, you may remember from U.S. history class, the case was ruled 8-1 that separate but equal was the law. It took 58 years. The wheels of justice turn slowly, but they do turn. And we saw a judicial interpretation much different than that. Unanimity in that court, ruling 9-0 in favor of Brown, that separate but equal is unconstitutional. We would see this in Griswold, a right to privacy case that would ultimately lead to the Roe v. Wade, the abortion case. So we see a lot of judicial interpretation, and a lot of it depends on the ideological makeup of the individuals on the court. That does tend to change, and we will see, to be continued, how that plays out in those that are on the court today. So we have two different schools of thought on this interpretation. We see an originalist point of view, which tends to be more strict constructionist. This is the idea that the Constitution is a fixed document. The words are not to be interpreted based on the here and now, the context of the changing times, but really what the constitutional founders meant in 1787. The adaptive approach is more of a loose construction, more flexible, more adapting to the context of the time that we're in. And we see this as more, hey, how would we interpret this if the founders were here today? There was no internet, so how would they look at the internet today? That's more the adaptive approach. Now, not to assign ideologies related to this conclusively, but we do tend to see that conservatives tend to be more originalist, and progressives or liberals tend to be more adaptive in their focus. But again, that's not a hard line to draw, but just drawing general conclusions based on what we've seen in past precedent. That's kind of how that plays out. Amending the Constitution, quite simply, notice there are two columns here. The Congress and the national government is on the left column, and this is what I call the 2/3 column. And then we have the states on the 3/4 column. So if you can remember it this way, it's probably the easiest. Phase 1 is the idea that the national government, the Congress, needs to get 2/3 vote from each House, the House of Representatives and the Senate, in order to amend the Constitution. They then send it on to the state legislatures or state conventions, and they need 3/4 in order to ratify it. Okay? So proposing and approving an amendment in Congress is different from ratifying. You need both of those in order to amend the Constitution. We've only done it 27 times, and you can see here with the arrows, I love this, it's from another textbook. This is actually from the Edwards and Lineberry text, but it does a really nice job of showing you that the purple, we've done this with Congress and state legislatures on every amendment except the 21st, essentially repealing prohibition. The National Convention and going to state legislatures or National Convention, going to state conventions, has never been used. And the reason, we know why the reason this is, Madison was very afraid of calling for another National Convention because the concern was they're going to throw out the Constitution altogether and start over. So that's why we don't see a lot of calls for national conventions because of that precedent that Madison set there. But we have seen, as I mentioned, the 21st Amendment, in which Congress approved the amendment by a 2/3 vote and sent it to state conventions that then approved it by 3/4 of the states in signing on to that. So a state can't unratify an amendment. Once they've ratified it, it's done. Okay, that's to be clear. There's no time limit unless Congress specifically gave a time limit for it. Notice that the 27th Amendment I talked about was originally proposed by James Madison, and it took over 200 years to ratify that amendment. It was actually a student, I think, from the University of Texas that took it on as a project because he got a low grade on a paper that he wrote, and the teacher said it wasn't possible that the states would ratify it at this time, and he took that as a challenge, worked with states, and actually ended up getting it ratified and amended. The 27th Amendment today is as a result of that. I believe the teacher did change the grade from a C to an A. And then the last one, the last bullet there, the idea today, we see a lot of times, if Congress is going to put a time limit on it, it's going to be 7 years. The National Rights Amendment, the Women's Amendment that was passed in the 70s, the time limit expired on that. But the support that it has, the National Rights for Women, continues. We hear members of Congress that will talk about it from time to time. But the issue there is that unless Congress sets a time limit, there is no time limit. And on one of those original amendments that were proposed, they had plenty of time to make up. So we're moving towards more of a direct democracy, even though of the pluralistic structure, that's never going to be possible entirely, 100%. But we have expanded the electorate. You can see here with the amendments that have been proposed and ratified, the 15th Amendment with African American men, 17th Amendment with U.S. senators, us voting directly on that, the 19th Amendment for women, and the 23rd Amendment with D.C. getting the right to vote in Electoral College. We have expanded the electorate. It doesn't always mean that more people are voting. It just means, and by that I mean as a percentage of the population. We still are one of the lowest percentages of people in a country that votes because we do a lot of other things really well. We go out to rallies and we join interest groups and we give money to political parties and elections and campaigns. But voting, we just, for some reason, we always stay home to wash the cat. Don't know why that is. At any rate, I hope you found this helpful, and good luck on the upcoming quiz and test, and we will see you in Chapter 3.